Nigeria's Presidential Election Tribunal on Wednesday rejected challenges by opposition rivals to President Bola Tinubu's win in February's disputed vote, following a pattern seen in previous election years since 1979, despite a culture of electoral fraud. No legal challenge to the outcome of a presidential election has succeeded in Nigeria since the return to democracy in 1999, after 3 decades of almost uninterrupted military rule. Atiku Abubakar of the People's Democratic Party, Peter Obi of the Labour Party, who came second and third, respectively, had asked the court to cancel the election, alleging irregularities. But justices of the five-member tribunal, taking turns to read out judgment for more than 11 hours, rejected Atiku and Obi's individual petitions point by point. Justice Haruna Samani said Obi's petition was unmeritorious and had not led any credible evidence sufficient enough to back claims of irregularities. Samani said Atiku's allegations of vote fraud were so lame and dismissed his argument that Tinubu was not qualified to run for president. Obi's Labour Party, in a statement, rejected the judgment and said it would announce its next step after a meeting with lawyers. In a statement from India, where the president currently is taking part in the G20 summit, well, the president welcomed the tribunal ruling and urged his rivals and their supporters to support his government. Well, European Union observers had said in June that the elections were marred by problems, including operational failures and a lack of transparency that reduced public trust in the process. We have our guests with us, and we'll be looking at this. Our guest this morning, a barrister at law, Eze Eluchie, who is also a public affairs commentator, and Victor Atewe, a public affairs commentator. All right, so welcome, barrister. Good morning to you. All right, Barrister Izzy, I would like for you to unmute your microphone because we can't hear you at the moment. So please do unmute your microphone. We expect Victor Atewe to join us much later. But in the meantime, we have Nick Agule with us as well. Good morning to you, Nick.
Good morning. Good morning to our viewers.
All right. Still trying to get Barrister Izzy online. Barrister Izzy, have you helped us to unmute your microphone? Okay.
I am hearing you, yes. Okay.
Oh, great. Fantastic. So here we are. It's been 5 months down the line. The court, has been deliberating on evidences brought before it by the petitioners. And at the end of the day, this is the judgment. Topmost of it on the minds of a lot of Nigerians is the judgment that talked about the FCT, 25% of votes cast, and the FCT. What do you make of the entire process, and this point in particular?
Thank you very much.
Barrister
Yesterday was a very sad day. Yes, yesterday was a very sad day for the Nigerian judicial process, for the legal profession, and for the rule of law in Nigeria, because the tribunal virtually overturned our notion of justice and the jurisprudence we have in this country. I'll give you two critical issues where this tribunal paid a foundation that is very injurious to the Nigerian state. One is in the issue of subpoenaed witnesses having their witness testaments on oath before the courts, before the end of the application. Normally, the court issues a subpoena after the matters have been filed and the witnesses, because these are witnesses we are bringing in by order of court. It is impossible to file a witness who is on subpoena to file his statement on oath at the moment of filing the application. It is totally impossible. You can only, because the case has to be in the court's docket, then you apply to the court for this witness to be summoned to court. There is nowhere in the world where you file a subpoenaed witness's testament in court at the time you are instituting an action. So on that ground, this tribunal said it will not hear or factor in the testimony of several witnesses, thereby jeopardizing the entire case of some of the political parties, some of the petitioners. This was a fundamental gross error. A second fundamental error, it's indisputable, is the issue of when a party can challenge the authenticity of a candidate. In the case of the PDP and APC, the Supreme Court had held that no party who is not a member of a political party or who had contested in the primaries can challenge or has the locus to challenge the nomination process of any political party, which means any person who is aggrieved, any political party who is aggrieved with the process has to wait until when an election takes place or when a party submits its candidate to an election before it can have a locus to challenge. Now, what the tribunal ruled yesterday was that challenging nominations is a pre-election matter. It's a pre-election, thus throwing mud on the Supreme Court of Nigeria. You don't do that. The tribunal is subsidiary, is subservient to the Supreme Court. If the Supreme Court had ruled that you do not have the power to challenge the nomination process of a political party, if you are not a member of that political party, or if you did not participate in the primary, for this tribunal to have now told the litigants yesterday that the challenge to challenge the nomination is a pre-election matter, and thus they have waived that right by not challenging the nomination of Mr. Tinubu and Mr. Shetima before elections, is ridiculous and an affront to justice, because what it means is that nobody can challenge the nomination, because already Supreme Court has said you cannot challenge it if you're not a member of the party or you participate in that primaries. Now, the parties have waited, as they should, because the only time when a nominee or a candidate of a party becomes to other political parties is when that candidate who is nominated presents himself for an election on election day. Because a candidate can say, I'm withdrawing before the elections, and then there will be no need to sue him. What the tribunal told Nigerians is that all the political parties, if you want to challenge any nomination by any political party, you have to go around the entire 18 or the 19 parties or all the parties who submitted candidates to look at them and then begin to file pre-election matters. And that is, I will shy away from using very strong words. But these two actions, these two fundamental flaws that the court tribunal laid, gave rise to all the other errors that followed suit. Because you simply don't do those basic flaws. And so based on that premises, when you look at those fundamentals, you realize that when you have a weak foundation, when you have a weak, defective foundation, all other things you place on that amounts to naught. So I will encourage Nigerians, do not lose hope. We still have a Supreme Court out there that will tell the judges who have failed to apply justice to issues that what they did was wrong, not just wrong, but extremely dangerous. Extremely dangerous in the sense that when parties can no longer challenge a nomination, a nominated candidate, that means if a ruling party on its own coven decides to bring somebody who is inherently not qualified, maybe an insane, and the party that is ruling, the ruling party produces an insane person as their candidate, no other party can challenge such absurdity. That is the implication of the ruling of the tribunal. And as a lawyer who has been in this practice for over 30 years, I feel that that was a slap on the face of the judiciary, on the face of the legal profession, and on the face of the rule of law. Let me allow others to make that mistake.
All right,
Thank you.
Thank you very much.
Thank you very much, Barrister Eze. Nick, good morning.
Good morning.
Yes, good morning. So,
Yes.
okay, the courts ruled yesterday that LP didn't have, that's Labour Party, of course, didn't have enough evidence against the APC. Now let's come to section 134, subsection 2 of the 1999 Constitution as amended, which provides, and I quote, "A candidate for an election to the office of President shall be deemed to have been duly elected where there being more than 2 candidates for the election. He has the highest number of votes cast at the election and must have nothing less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation and the Federal Capital Territory, Abuja." So how do you place, this side by side with what the court said about this same matter, in its ruling?
Thank you very much. I am not a lawyer, so I have to put that forward. I'm not a lawyer like my co-panelist. I'm a public affairs analyst. I take interest in public matters. And for me, I always knew that this provision that talks about 36 states and the FCT can be interpreted either way. Because let's look at it carefully. If we interpret that provision to say you must have 25% in 2/3 of the 36 states, and you must have 25% in the FCT, then that places the FCT above every other state. That means if a candidate polls 25% in all the 36 states and has the highest votes, if a candidate polls a minimum, a minimum of 25% in all the 36 states and has the highest votes, but is unable to secure 25% in the FCT, we are saying that candidate cannot be elected as the president of Nigeria. That gives the FCT like a veto power. That means whoever is elected, whoever is elected president, the FCT must say yes. If the FCT says no, then regardless, you could have 100% of the votes in all 36 states. But if the FCT says no, and they don't give you up to 25% vote, that means you have failed in your bid to be elected president. I don't think that would have been the thought of the framers of the Constitution in putting the Constitution together. So what I heard the Supreme Court justices say yesterday was that
Tribunal, not Supreme Court.
Sorry, the Presidential Election Petition Court said yesterday. Thank you, my co-panelist. Said yesterday was that provision is interpreted to say you have to have 25%. You have to have at least 25% of the votes in 2/3 of the 36 states and the FCT. So that is, they are putting 36 states and the FCT, making it 37. You must have to have 25% on the minimum in 2/3 of 37, the way the Presidential Election Petition Court interpreted it yesterday. And they said the FCT needed to be mentioned because it is not a state as it is. So if you want to say you must have, my interpretation of it as a layman is that if you have 36 girls and 1 boy, and you are saying somebody must have to have 25% you have to say 25% into tests of the 36 girls and the one boy, so that you have 37. So for me, I mean, it will be terrible to say that a presidential election is upturned only because those in the FCT didn't give a candidate 25%. So I wasn't surprised with the decision that was reached by the presidential election petition court yesterday.
All right, then. Thank you very much, Nika Gule. So let's come to Barrister DME Bironke, because we have another barrister and would like to get his views. Good morning to you, Barrister Bironke.
Yes, good morning to you.
So now let's get your overview, really, of the process and the verdict as it was.
Yes, thank you very much, and good morning to my co-panelists. Good morning to everyone in the studio as well. Let me start by agreeing with Mr. Agule. I hope that my pronunciation is right, on his very simplistic explanation of the 25% FCT issue, coming from someone that is not a legal practitioner, because as we say in law, justice is not only done but must be seen to be done from the view of the reasonable person, which is the people out there. So I appreciate his very simplistic explanation of that provision of the Constitution. And before the elections, I had written a legal opinion on the point. With regards to whether or not the FCT, based on that constitutional provision, in fact has a special status. And I told the same line of the court, the tribunal, as well as Mr. Agule, that no, I don't think that is the logical reasoning of the framers of our constitution with regards to that issue. And talking generally about the decision yesterday, I think for a lot of people that often say waiting lawyers they do self, I think we have to appreciate that the industry of legal practitioners and the members of the bench, because even for we lawyers, following the reasoning of the courts over the several issues, combing through the evidence, it takes some skill and it takes a lot of patience. So I'll commend the panel of the tribunal on the industry they did yesterday, dealing with all the issues, analyzing the evidence, and then coming to a conclusion. Now, as Mr. Eluche has stated, fine, it's the first step on the legal process. And I've always maintained that the electoral process, of course, started with the campaigns. We went into the elections proper, and we are still going through the electoral process in Nigeria with the petition and a further appeal to the Supreme Court as the court of final jurisdiction on this matter. So it's still an ongoing process, but ultimately, yes, there may be some flaws here and there in the decision. We cannot always get it right all the time to the satisfaction of everybody. But I think I'll just say that, yes, since we have the Supreme Court to now hear and finally determine some issues that people may not agree with, then we'll keep our fingers crossed and wait until then.
We're talking about flaws and getting it right and all the time. This is a crucial time, really. This is a time where Nigerians, a section of Nigerians are concerned that their votes did not count, regardless of the fact that they came out to cast their votes. Another section of Nigerians are, in a celebratory mood that, yes, this is, this is affirming their victory. But let's look at, I'm staying with you now, Barrister Ibironke. Let's look at the APM's, the verdict that was passed on the APM, where the court says the issues raised contained pre-election matters that could only be determined by the Federal High Court. I think Barrister Eze Eluche chimed in on that. I want you to go deeper into that, really. What do you make of that judgment?
Yes. Now, like I said, the court yesterday took its time to really deal with a lot of these issues. Now, in law, we deal essentially with facts and evidence. Like you rightly said, emotions ran wild at the last general elections. We saw the chasm amongst, people really exploited what differentiated us as opposed to harnessing what unifies us and our diversity. So I think that's why the courts had to go to great lengths in addressing some of these issues and almost walking eggshells in reaching a conclusion yesterday. Now, there are precedents on what amounts to and constitutes pre-election matters, which are issues that ought to have been resolved because the truth is the Electoral Act and election petitions are very specialized area of law. They have their own laws, they have their own applicable rules that applies to most of these issues. And because of that, we are seeing a scenario. We are seeing a situation. Are you with me?
Yes, yes. Yes, we can hear you.
Oh, okay, sorry. So I think because of that, we are seeing a scenario where everybody tried to be careful, including the panel yesterday. And I think the panel went to great lengths to explain in detail and in very simple language what the mind of the court is, especially with regards to precedents. Now, there has been precedents in the past with regards to the issue of what constitutes pre-election matters. And the only issue raised by the APM petition was on whether or not the parties, the candidates of the APC, the ruling party, were qualified to run to participate at the election. And the court held that on that issue, it was a pre-election matter that should have been resolved at the Federal High Court prior to the elections taking place. So it's just an interpretation of the law and existing precedents on the point that we saw yesterday. And that's why I think Mr. Eluche is trying to draw back to say, okay, let's go and hear again from the Supreme Court if or whether or not the panel yesterday was right or wrong. But ultimately, I think the panel's interpretation of precedents and of existing precedents and the laws suggests, according to them, that those matters fall within pre-election matters and should have been resolved as such.
All right, then. Thank you very much.
Thank you very much. This is for you, Barrister Eze. Okay, I'm not a lawyer, so but I would like to hear from from the legal perspective. Do you think Peter Obi, of the Labour Party, was actually prepared for this feat? Because from what we saw yesterday, most of the petitions, tendered by Peter Obi, that's Labour Party, were ruled out, and even 10 out of the 13 witnesses, were rejected. Do you think they came prepared? Because even I think today it was alleged that the national chairman of Labour Party has come out to say that he actually talked Peter Obi out of this whole thing on going to court and all of this. What do you have to say about this? Do you think Labour Party, Peter Obi, as a matter of fact, came prepared, with all the facts and figures to actually get this right?
Well, before I answer that question, let me just address a bit on the issue of 25% in Abuja. The law did not say that if you don't have 25% of the election will be overturned. What the Constitution says is that if you don't have that 25%, you will not be declared a winner at that first election. And then they will now proceed to a runoff between the person who scored all the who met all the criteria, but didn't score that 25%. So the issue of equality of Nigerians not arise in this instance. If the makers of that constitution had deemed it fit, know that Abuja is a federal territory, to add it that you must have it to that extent of the votes in Abuja, then that simple request has to be fulfilled. And if it's not fulfilled, then there must be a runoff between the people who fulfill that and the person who is adjudged to be the second candidate for a runoff. But with regards to the question you asked about the Labour Party candidate, like I told you, once a wrong or a faulty premises has been laid, all other things built on it is superfluous. It's waste of time. The court had the tribunal had laid a very wrong foundation. And I can say this anywhere, and I'm sure my colleague in the studio will agree. There's no way you can file a subpoenaed witness's statement on oath before the filing of an action. Simple. So the 10 or whatever number of witnesses that the Labour Party brought that was discountenanced is to the shame of the tribunal, because it upturned the basics of law. You don't do that. You can only file a witness statement on oath when the court has invited, after the order has been filed, and the court invites you to bring these witnesses, because the court subpoenas them, the court orders them to come in. So it is a time when they have been at court to come in, which you now submit or tender their witness statement on oath. In fact, the evidence act is to the effect that you don't even need them to have a witness statement on oath. They can just come in and testify. But for clarity purposes, lawyers like to submit a witness statement on oath for subpoenaed witnesses. So the number of witnesses that were discountenanced is inferior to the justice of this case. And I believe that at the appropriate time, the Supreme Court will, for that matter, re-invite or re-evaluate those witnesses. Because what the tribunal did by cancelling all those witnesses makes the whole matter that was filed by the Labour Party look childish. And that was the whole intent. But if the foundation, like I said, is wrong, it is wrong. I don't think the issue of the Labour Party chairman told Peter Obi, all those are hearsays. There are legal issues to be determined. And was the court, was the tribunal wrong? Wrong. And I'm using that word wrong because there's some base that even a first-year law student is aware of. You cannot file a witness statement who has been subpoenaed by the court, because before the court subpoenaed them, they were non-existent. How do you file a statement of non-existent? They only exist in this case because the court has subpoenaed them, and the court only subpoenaed them after the deadline for filing of cases has lapsed. So let people not be worried. We have more cerebral mind in the Supreme Court who will properly adjudicate this matter. I'll leave that at this stage.
Now, let me ask Nick this. This is Nick. Are you still there?
Yes, I'm here.
Oh, great. Thank you. Now, let me ask you. I thought Nigerians were asked not to protest. Nigerians were asked not to demonstrate, as the tendency for that to go out of order was high. But in Abuja yesterday, we saw Asarido Kubo and his friends marching on the streets, chanting their support. And there were no policemen, standing around to ensure that, hey, this doesn't go out of control. What do you make of that?
This is a situation where if we don't place everybody equally before the law, we're not going to have a country that we enjoy. And we will continue to see our brightest, our young people jackpot from this country to countries that are placing everybody before the law. First of all, it is undemocratic to ask people not to protest. That is why we have the police and the other security agencies to ensure that there's no breakdown of law and order when people are protesting, because protest is an ingredient of democracy. And if you say people should not protest, you are actually trying to muzzle their voices. But at the same time, you say people should not protest, but the person who is supporting the incumbent or the person who is in power is allowed to protest. And that is why, for me, I posted on my social media handles yesterday as this whole, this whole judgment was being read out. I posted that there is a simple solution that we are going to have to this situation. And that is, instead of conducting elections in February, let the National Assembly amend both the Constitution and the Electoral Act to move the conduct of elections to November or December of the preceding year, so that elections are held in November or December of the preceding year. Like the next election is in 2027. So hold the election, the next swearing in is in 2027. So hold the elections in November, December of 2026 and allow 6 months for the courts to exhaust the whole legal process, so that on the 29th of May, you are swearing in people who have been declared winners by INEC and affirmed by the courts, including the Supreme Court. This whole idea of letting people get sworn in as president, as governors, as senators, or whoever, and then you are now saying someone should take them to court. Immediately you will see that an institution like INEC, their conduct was very shameful, I must say. Behaving as if they're a department under the presidency, refusing to give evidence. INEC should not even be a party in this petition. INEC should be neutral, so that INEC being the umpire, if it is the petitioners that ask for evidence, INEC will give them evidence. If it is the defendants that ask for evidence or the respondents, INEC will give them the evidence. When you sue INEC as a respondent, INEC is coming out to defend itself, to justify whatever they did. So for me, these are the fundamental things that we need to fundamental steps that we need to take before the next elections, so that we will avoid all these shenanigans that has played out now.
Barrister Bironke, do you share the same opinion with Nick Agule that the incumbent or the sorry, I beg your pardon, that the presidency will influence INEC's decisions or the courts as it is now? Do you share that same view, Barrister Bironke?
Thank you very much. Ideally, I'm talking from an ideal point of view. That is not supposed to be the case, because in their name, that's why they have independence in their name. So I think what we need to work on still remains that we need to fix our institutions in Nigeria. We need to go from the current era where we have strong men and cross into the area where we have strong institutions. The moment we do that, then our institutions will be truly independent, irrespective of what happens or who is sworn in or who forms an interim government or what have you. And I'll use the January 6th insurrection as an example. What saved the American 2-century-old plus democracy was the fact that they had strong institutions. So even when 50% of the population, technically, of Americans, when their supporters stormed the US Capitol, the institutions rose against that, even though it was the government in power, and they said, no, we need to do what needs to be done. Mike Pence, the vice president, and the designate in Congress took the bold step and said, no, I will reconvene, and we would certify these votes and say this person won the election. So that is where institutions and their independence come into play. And that's what we need to focus on in Nigeria, to say, okay, going forward, let's learn from these events, these things that happen in the country, and then shape our democracy to suit the kind of people we are. So that is what we continue to, we have to keep working on. And then before I drop anchor, I'll just quickly respond, but humbly disagree with Mr. Eluche again on the 25% issue. Yes, we don't need to go back and forth. The tribunal has made a decision. The Supreme Court would eventually have an opportunity. I'm sure the issue will still come up. and the Supreme Court will again have an opportunity to deal on that issue. But I think the decision of the court on that point was valid and was right. And then with regards to 10 Labour Party witnesses being removed because of the subpoena, the courts went to great lengths, like I said, to explain their reasoning. And what they explained was that these witnesses that were subpoenaed by Labour Party were actually witnesses available to Labour Party ahead of the filing of the petition. So they are not witnesses that are third party, government officials or what have you. These were people that were in-house and available to Labour Party ahead of the filing the petition. So in other words, what the court was saying was that they could have filed their statements on oath along with the petition because they had access to these people. So I think that was my understanding of the decision of the court based on what was delivered yesterday.
I'm going to ask you a question before we allow Barrister Ezeliche respond, because I think he wanted to chime in on something that you said. Now, let's just talk quickly on the issue of mandatory transfer of results electronically. The courts did, strike that one out. Says that no law says INEC must mandatorily transfer results electronically. But we thought there was something different before the elections, and that actually made Nigerians come out in their numbers to cast their votes.
So the court also explained that. The court said, looking strictly at the Electoral Act, which is the law regulating conduct of elections in Nigeria, that act did not stipulate electronic transmission of results. That what stipulated electronic transmission of results was a regulation, in other words, like a bylaw, so to say, of INEC. So it's INEC that decided that, okay, we would have guidelines to assist us to run this election transparently, credibly, and what have you. And the way to do that was to now come up with electronic transmission of results. So when push comes to shove, and the law is clear on the point, there are lots of precedents on that issue, that a bylaw, a regulation, or what have you, cannot supersede and trump a legislation, an act, a law made by a statutory body. So that was the basis for this decision of the tribunal yesterday, to say that the Electoral Act, and that going back, that this kind of boils back to my previous statement, that what we need to work on is learn lessons from the 2023 elections and say, okay, what do we need to do? What do we need to amend? If you recall, if you cast your minds back to the 2022 amendment of the Electoral Act, you know that there was a lot of back and forth between these major stakeholders on some of these issues, and even electronic transmission was supposed to be incorporated into the act, but it was expunged. I don't know if people recall that. So this is what we need to do, to say, okay, going forward, how do we make sure that electronic transmission becomes part, at least, of the act, and then give options to say, okay, should something happen, something unforeseeable happens that electronic transmission becomes impossible, then of course we revert back to the manual transmission. But let us put it in the act and then give some kind of bite to our electoral laws.
Thank you very much.
Okay.
I'm hearing Victor Atewe has joined us virtually. Good morning, Victor. Good morning, Victor. Can you hear me?
Good morning. Yeah, good morning. Good morning.
Okay,
and
good
thanks
morning,
for having
Victor.
me.
Okay, so what do you make of the verdicts, by the tribunal yesterday? What do you make of it? And Peter Obi, of course, has said is still going to the Supreme Court to to continue this whole process, and is very positive about this. What do you think about that? Do you think at this point it should just rest, like we say in the Nigerian palace? Do you think it should just give up on this and just, let sleeping dogs lie, and probably in the future you can then contest again? Do you think that is, can you hear me?
Yeah, I can hear you loud and clear. I wanted you
Yes. So do you
to
think that
land on
is the
your
way to
submission.
go, or should he just keep pushing for this?
Okay. First of all, it's within his right to contest it to the Supreme Court, and that is why if you check the record of Peter Obi, you know that is a man who believes in the rule of law, and he believes that no matter how delayed it might look or seems like, the law would take its course. Now, back to your question as regards to what my view about the tribunal verdict yesterday. Trust me, this goes to show, goes to affirm many doubts that our judiciary has been infiltrated, and of course this goes to further weaken the institution, as it were, because there's so many verdicts that were given yesterday, and a lot of people will keep wondering, like, this is what our law says, and this is what we're seeing, or this is what is being said. Now, we all understand that there is some technicalities. All this being said, like Mr. Adeyemi was saying, it's those are technicalities. Those are not. Now, if the INEC, as it stands, INEC is a product of the law. So meaning that whatever INEC stands as a law and must be abided by, But INEC coming to be a party, like a department under the ruling party, and taking sides, this goes to show that everything we saw yesterday was a scripted proceedings. My view, a scripted proceedings, because um how would you say a case that is being judged in America, and there's a proceeding to that, and all you can say is it does not count, meaning that, for instance, a victor can be accused or not accused, convicted in America or UK, as it were, and I could come back in Nigeria and vie for the number one seat of the country, and of course win, putting all the machineries, in place and win. And whereas our law says that once you have any criminal charges, you are not liable, you're not fit to contest for that office. It goes to shows that whatever we sow today, no matter which size you are on the divide, definitely tomorrow you reap. So I think it should go further. I think this is not what Nigeria
sorry to interrupt you here, Victor. As it is, you know how court cases are. It's not about what you did or what you did not do. It's what you're able to prove in court. Now,
very true.
the ruling was that the PDP were not able to prove the allegations of criminal conviction. So if the lawyers were not able to prove it, should the judges, grant it just because the public feels it is what it is? I don't think so.
I'm not a lawyer, so I'm not going to speak as a lawyer in this case. I'll speak as, of course, an analyst, and of course a concerned Nigeria. Now, first is you could say that the lawyer were not able to prove it, as it were, given to some instance being cited, in the judgment yesterday. If you read that, now it is not about, there is a conviction being made, a forfeiture, an admittance to a deed is as good as committing the deed. That is why there is a plea bargaining law. What's it called? The barrister here is going to throw more light to that. There's an admitting. For you admitting that, yes, I am ready to forfeit this, means you did it, but it's a plea bargain. So what other, I'm here to understand, or I need a better or a supreme submission or argument to make me understand what other conviction do they need, or do they need to say, yes, you're a criminal, as in has been written point blank? I don't know if that's what they want, but if that's what they want, I mean, if you read the judgment from the United States, that
Sorry,
for the
can I chip in
conviction.
here?
Can you hear me? Can you hear me? Okay.
Please, I'll come to you. Just go, please.
This is driving a bit strong. Yes. What I wanted to say is, Mr. Nick had raised.
I would like for you to finish your line of thoughts, and then we'll go
Okay.
to Barrister Eze Luche. So just finish your line of thought, please. Victor?
Okay.
Yes.
Yeah. Okay. Yeah. I mean, admitting to a crime to say that I'm ready to forfeit this, and of course, proof to it over $450,000 is as good as you committed it. If you do not, there is no need for you to let go of that. Well, that being said, we were going to wait for the Supreme Court to hear their own side and what the ruling on this case. But for me, I think it's a daylight. I'm not surprised, but in a way, I'm not happy.
Well, I can see that from your face. I can see that. Thank you very much, Victor Atewe. Now, Barrister Eze, you were going to say something. Please, you have the
Yes,
floor.
I wanted to say that I very much agree with what Nick said about having the elections at least 6-7 months before transition, so that whatever legal issues will be addressed. And then I also want to mention what my learned friend said earlier. He had mentioned that the regulations made by I will be announced with. You see, that is the third aspect of our law that the tribunal in its judgment rubbish. The bulk of laws that govern us in Nigeria are regulations made by agencies. And they make these regulations based on the laws that set them up. Very few laws are in existence. And the regulations include traffic regulations, regulations regarding the health sector, regulations regarding elections. The bulk of our laws are regulations. So what the court did yesterday was to tell us that those regulations amount to rubbish, that we can only revert back to the laws. And look, the regulations, if they are inconsistent with the laws, they are nonsense. But when it is only there to augment, to help the law, it is very, very wrong for a tribunal to come and now tell us that all the utterances, all the assurances, all the regulations INEC read out amount to naught because it is not mentioned in the Act. The Act says that there will be transmission. The Act does not have to say how that transmission will be done. But the INEC regulation now went further and stated how that transmission of the votes or the tallied votes will be done. The tribunal had the temerity to say that those regulations done by INEC are immaterial. Now, what this means is that Nigerians, based on this judgment, we can forget the traffic regulations. We can forget all INEC regulations. We can discountenance anything that the INEC chairman says. If you stand up somewhere, tell him to go to hell, that the tribunal says it's only the that can rule, and that the act does not provide that we should stand somewhere. We should be very careful in this country because those two phenomena that I've mentioned have led to the basics of our jurisprudence, the basics of the rule of law. And the third error, let me be my last comment in this issue, is the tribunal mistook the issue of criminal conviction, which is properly captured in section 1371E of the Constitution. That is where the term provides for criminal convictions. That if any person has been convicted within the past 10 years, he cannot stand for presidency. So the section that the parties relied on in their petition was section 1371D, which fines or forfeitures relating to any offenses bordering on the fraud and dishonesty, not conviction. You see, the method of the Constitution are not foolish. If you provide for criminal convictions in one portion of the Constitution, it is presumed that wherever else that issue is mentioned does not really relate to convictions, because the issue of criminal conviction is settled in 1371E. So in 1371D, where the parties are now saying that the fact that Mr. Tinubu made a forfeiture they don't have to establish that he was convicted. I mean, and that is simplistic. It's simple enough. But the court felt, or the tribunal ruled, that section, they must establish conviction, prove it beyond a reasonable doubt, and all. I mean, the court was imputing criminal level of proofs in a civil action. The court, for instance, said that for them to say that Shetima allowed himself to be nominated twice, they approved the mens rea guilt, the guilt intent and attributes. Come on, who does that in a civil action? The issue is, was he nominated twice for the same office, even if it's for one day? Nobody has to prove that he had a guilt intent or he did anything. And if the fact is that for 1 minute, Shetima was on the papers as having been a nominated vice president and the nominee senatorial election, he stands disqualified. So the ruling of that tribunal was offensive to any lawyer who has practiced in Nigerian courts for a while, because it upturns our jurisprudence, it upturns our rule of law system, it upturns our judicature. It even insults the Supreme Court in several arenas. So that's what issues are. And the parties have rightly said they will go to the Supreme Court. Let us not take these things for granted. Nigerians, if you deny people justice, and there's an aura of injustice, the peace you have is the peace of the graveyard. And at the slightest spark, we will see what will never thought existed. So let the system be very, very careful. And finally, the issue of Atiku and his gang parading and making noise all over is to the eternal shame of Egbeto, who is the IGP, and the army chief, the DSS, who were making all kinds of public pronouncements, condemning rallies, condemning the protest. And the protest was taking place right in the vicinity of the tribunal, and they kept quiet. They should bow their heads in shame, and they should not be surprised or annoyed when next they reel out sort of orders and Nigerians don't respond to them. Because what they did was an affront to common sense. Somebody cannot be brandishing weapons and everything within his premises, and you say people, you have told people not to riot, not to protest, and there were some radical elements protesting. Is it because the same Atiku is in cohort with Mr. President, with the placeholder president? If there is no equality before the law, then why would we be bothered about obeying the law? The
All right,
was serious to talk of rule of law. It's so annoying.
Okay.
Thank you very much, my brother.
Well, I'm going to ask this question. I would like your responses, all right, to this. But I'm going to start with Barrister Adeyemi Birunke. I would like you to respond to this, and then every other person will also give me their opinion as we wrap up. You can wrap that with your final thoughts on the matter. Now, quickly, Barrister Birunke. Now, would you say there was substantive justice in this matter, as opposed to the many technicalities on which the ruling has been given in favor of the president?
Thank you very much. This may be unpopular opinion, but I would say yes, substantial justice was done based on the decision of the court yesterday. And I said it starting off this program. When I was talking initially, I said the courts went to great lengths to state the reasoning of their decisions. And based on that reasoning, it is my view that they delivered on major aspects of the petition. And you would also recall that I said the decision could not have been perfect, but on major acts or major points on whether substantial justice was done, it is my view that yes, substantial justice was in fact done. And then before handing over, I'll respond to Mr. Atewe, who asked that for a professional opinion on the conviction of the APC candidate or the president with regards to the 460,000. Back in this, I think November last year, I also wrote a legal opinion on that point because people were asking the question at the time, and they said, hey, Bola Tinubu was convicted, so therefore he could not. I didn't even go into the aspect of the 10-year statute of limitation constitutional provision. I just focused on the 460,000 forfeiture that was done in the US in 1996 or so. And my position was that action flowed from a civil proceeding, which is the same argument that the court told yesterday. Now, I used a simple scenario of a lot of us probably argue based on our interaction with the Nigerian police, and from what Mr. Eluchi has referred to, and Mr. Atewe as well, that there is an imbalance. We see a scenario in Nigeria where the institutions often toe the line of government in power, and they feel they are answerable to the government. And that's why yesterday we are seeing Asari Dokubo make statements and come out to violently, prove a point when people could not peacefully come out to say, okay, we do not also agree and want to state our case. So we are seeing that happen. But the truth is that in the US, it's much different. So the way law enforcement operates in the US, and I'm also licensed in New York to practice, so I'm familiar with the system out there. The way law enforcement works is that they can only pursue an action upon probable cause. So if they don't have probable cause, unlike what we see in Nigeria, where the police would arrest somebody, detain the person, and start investigating a crime. In the US, you cannot even arrest the person unless you've concluded your investigation and there's probable cause to suggest that that person has committed that crime. So that is the story behind the 460,000 forfeiture. It was a civil action that they said, okay, there's this money in your account. It didn't involve any conviction. It didn't involve any indictment. It was just, there's this money in your account. Is it yours? And the man said, the money is in my account. And they said, you cannot explain for it. We will take it. And that was the basis for it. So it's different. And then finally, I'll just address the issue about, in law, we understand the difference between ratio decidendi and obiter dictum. So the court, in dealing with the issue of double nomination and what have you, the ratio for reaching that conclusion was based on the fact that it is a pre-election matter. It was only part of obiter that the court now went to town to say, okay, some mens rea had to be proved. And that was why I started off by saying that, hey, listen, in my view, the decision was not perfect on all fours. There were some areas where I was a bit uncomfortable and skeptical on the application of the law. But if we focus on the ratio of that decision, it was that it's a pre-election matter, double nomination, and that is not, the petition was not a proper forum to decide on that issue. So that's generally my point on all of those few.
All right, thank you very much, Barrister Adeyemi Ibironke. Nika Gule, coming back to you now.
Yes.
Your final thoughts
here
on this?
Okay, so my final thoughts is that to answer your question whether justice was served yesterday, to me, if there are 100 matters before a court and the court finds 99 of them, finds 99 of them in favor of the respondent. If there is one out of that 100 that the court doesn't find in favor of the respondent, then the court should give judgment to the claimant. And to me, that is not what happened yesterday. So there are matters that, like we're talking about this double nomination, we're talking about this $460,000. I don't think that anybody can just concede $460,000 of their money if they didn't do anything wrong. I'm sitting here in the UK. UK government cannot just come and take money out of my account without any proceeding. How is that possible? So I think if one of those matters, the court found that the respondents were to be found guilty on them, then the judgment should have gone to the applicant. I haven't said that. My last thoughts are a couple. First, I think that the parties didn't do their homework as well. How can you go to court without tendering actual evidence? I mean, we have 178,000 polling units. If the parties were serious, they could have got people into a room to collect the results from IREF from each of the polling units and then tender the evidence to say, look, we had the highest vote and they were not given, or those ones were mutilated. The parties didn't do their work. I also have a problem with lawyers. I'm sorry, my co-panelist here. There were some issues like lawyers writing to the national electoral national chairman of INEC instead of the state electoral commissioners to request for evidence. And that's what the judges said yesterday. Why would lawyers make such mistakes? You know, is it sabotage or is it incompetence? And then, of course, there's the issue of the judges yesterday. I don't like the language some of them were using. For instance, there was one of the judges that talked about a measly 8,000 votes. Why are you characterizing the votes? You simply say that they had 8,000 votes. You didn't meet up with that. When you say measly, how can you be calling 8,000 Nigerians that voted and I saying is measly? One of the judges was talking about a defender having the audacity, temerity. I don't think this is correct language. That kind of language shows that the judges are angry that this kind of thing. The judges should be, neutral totally in the whole matter. So this is where my summation ends.
Very much, Nika Gule. Victor Atewe.
Okay. I think we all have, a kind of like mind, but of course, different. For me, in my opinion, is a rape to our institution, and this goes to deepen the lacuna in the system. And it's not just what we're doing is if we have a good, but that didn't play out yesterday. If you see the ruling of the judges, you would find out that there's this undertone. It's like, yes, it's okay to say that they didn't come out with it, but trust me, how would you, like you said, yeah, this is a court of law, you come with proof, you come with evidence. But if you recall, there was a time that the Labour Party Council was saying that the INEC refused, remember the word, refused to give them or to have access to the beavers. It took about intervention of Nigerians, and of course, so about a week or 2 or 3 for to the IRF, and of course to have results being presented to them by INEC. That they even said that they had to go and do the photocopy themselves. INEC couldn't provide. INEC had to say, okay, you have to do your photocopy yourself. So there were a lot of frustration in all the process to frustrate it so as to not to have the court. However, that being said, this election, February election, have been proven by all standards that it is flawed. Today at the tribunal, we saw a different tone. It's an abuse to our intelligence as a people. So for me, what played out yesterday, the parties involved should head to the Supreme Court, and Supreme Court will
a problem
correct
with your network
all that has been said by the tribunal.
Victor.
Can you hear me?
All right, so thank you very much, Victor Atewe. Unfortunately, some words you said towards the end of your thoughts there didn't come out because we had a network problem with your network connection. Now, let's take the thoughts of Barrister Eze Eluchie. Intentionally left you for last. Barrister Eze.
Yes, I believe, yes, the court dished out manifest injustice. And this is factored because it laid its foundation on 3 faulty premises. The issue of not allowing subpoenaed witnesses' statements on oath to be heard, and nothing then. Secondly, was the issue of nomination of being a pre-election matter. And third was the issue, the mistake it made in taking that the 460,000 must be a criminal conviction when that issue is taken care of section 1371E, while the petitioners rely on 1371D. They are very fundamental differences. But the whole injustice was exposed to some extent by the comments by one of the lawyers of the APC, Mr. Edo Someone, who is a senior advocate of Nigeria, who tried to urge the court to like exact word that the court should say they dismiss, and the court had to now say, hey, don't tell us what to do here. If you are confused, we're not confused. That exchange between the lawyers of APC who tried to tell the court in open court which languages to use, which words to use, And the response by the justices, the corrective responses, which showed that they were kinds of indignation, gave Nigeria a peep into perhaps what might have transpired. And we do hope that this matter gets to the Supreme Court, justice in its form will be dispensed. What happened yesterday was a travesty of justice that should be expunged from the record books. Thank you very much.
Sorry to just add this. What do you think of the fines? You know, that the Supreme Court meted to the three parties. You know, that's the Labour Party, the PDP, as well as the APM. You know, some huge millions right there. What do you think about that?
Those fines are as we can see, just like the humongous fines the courts were dishing out to those who are bringing matters for clarifications of the Constitution. Many people who sued that FCT votes should count. Different litigants before now who had sued matters were giving fines that were like scary. You wonder what the courts were trying to do. Were they trying to scare Nigerians off from litigating? So I think those fines also fall in line with the issue of the lack of justice which the court dispense. And it's immaterial, and we hope that the Supreme Court at the appropriate time deals squarely with such fines which have placed in our record books.
All right, I must say, well, we must thank you very much, Barrister Eze Eluchie, Barrister Adeyemi Ibironke, Nick Agule, and Victor Atewe for staying with us this morning. We honestly appreciate you for your time.
Thank you very much.
We'll take a break now. When we come back, we'll go into business, entertainment, and sports. Stay with us.